we had a very big trial in New Jersey, and plaintiff's counsel, who comes from an exceptionally well-funded, big, powerful plaintiff's firm, multi-million, maybe even hundreds of millions of dollars in verdicts, strolled in wearing the frumpiest outfit you have ever seen. She looked like like she went to Goodwill and bought her clothes.
Oliver, you do know this is 2020. You can't say that.
It was. I can say it because she did it intentionally. Yeah. He orchestrated this image for the jury of the Aaron Brockovich against the big, giant, multinational corporation.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hey everybody, welcome back to The Defense Never Rests. Joining me today is the normal crew, Nate, Wendy, and Oliver. Hey guys.
Good morning.
Morning.
Good morning.
So today we're going to talk about litigation and discovery efforts that get you the most bang for your buck. You don't do everything in litigation, but what really gets you the best return on your investment? And for this, we're going to kind of go through the different stages of litigation. And I want to first throw out to you guys, from just a 10,000 foot view, litigation strategy. Do you do everything that you can? How do you pick and choose what you do?
Well, go ahead.
No, I was going to say it depends on the case. I mean, I have some cases that just came in where I think that I can cut the litigation right off at the pleading stage. You know, the complaints are defective. In fact, I have a guy that just filed his second amended complaint and is calling me, asking me what kind of counts he has to put into the complaint. And I keep telling him I'm a defense attorney. I don't tell people how to sue my own clients.
What about you guys?
I think one of the things that we do especially is every 30 days, as we've talked about before, we do a comprehensive status report to our clients and carriers. And that gives us an opportunity to kind of reconvene, get our mind right, look at the thing, kind of not get in the nitty-gritty of the case, but step back up to a 30,000-foot view and say, what do we need to prove our case? What do we need to have on the record here to mount our defense? And we don't just blindly throw money at every deposition. At the same time, we're not lazy and we don't not take depositions. So we kind of look at it and say, here's what ultimately we need to prove our defense. Here are the elements we need. How do we get there? And then we strategically pick the depositions we take based on that. And I think that 30-day window over and over and over throughout 3 or 4 years of litigation really does help, kind of ground you and get you back to a good spot.
Yeah, I agree.
So, I mean, to me, the phrasing, do you do everything that you can, is kind of tricky, because on one hand, that makes it sound like, do you do everything in your client's best interest versus do you do everything that would be legally permissible within the confines of litigation? The latter, I don't think, is really a good way to be practicing. In these bigger cases where you have lots of witnesses, lots of documents, lots of experts, if you just did everything, it's not just picking the 1 or 2 fleas off the dog, it's a flea dip procedure. If you did that, your bill would be so catastrophically high, and the return on investment would be disproportionately low. So we have to really think about where do we want to expend our efforts in an effort to position ourselves to prove, and I say prove because we don't disprove things, that's a kind of a fallacy, to prove what we need to in order to either get out of the case via dispositive motion or to position for resolution that is tolerable. Let's put it that way.
Yeah. I agree, and I think it is picking your battles. It is first identifying the battles and the issues that you do need to prove, and then what's the shortest line to that. Sometimes we can zigzag in this litigation and it wastes money. But figuring out how we get there, do we need an expert or can we get it through witnesses, that sort of thing. So that's what we'll talk about today. So let's start with what most cases start out with is pleadings. What do you think gets you the most bang for your buck in the pleading stage? I'll throw it to you, Oliver.
Probably, if we're going to include venue removal, that sort of stuff, that's probably your biggest bang for your buck. Beyond that, I think punitives get you a lot of bang for your buck. In the products world, we don't actually see a lot of punitives being awarded. I mean, in some of the mass torts, you do see that,
But a lot, they're always asserted.
Yeah. But in our cases, they love to throw them out there, and I think that that's largely a leverage point, a button push against your client. Like, well, there's always these punitives hanging out there. So if you can wipe those out early, that's the way to go. I've been finding more and more that the better opponents that I'm going against voluntarily let them out. They understand that it's kind of a long shot, particularly when they have other defendants in the case who are like negligence defendants, because it's really hard for them to get punitives against a manufacturer. Not impossible. It could happen. We've seen it come pretty close a couple of times, but beyond that, I think those are your biggest things. A lot of people like to gripe over Connor objections. And the only reason I ever do those, and
Explain what they are.
Yeah, the Connor objections are. It's named after the seminal case on the issue, but
in Pennsylvania.
Yeah, it's basically where a plaintiff will say, and any other such conduct that we discover that we think you shouldn't have done. It's general. It doesn't mean anything. In my humble opinion, whether they assert it or not in writing, that's always in there anyway. It's improper, and because under our rules of civil procedure, you have one shot at preliminary objections per pleading. You got it's use or lose, all or nothing. Put them in or don't. I always put them in for that reason. If they, if there is a potential spam caller, I put the preliminary objection to the Connor issue. Only because you're required to. I don't want to waive that and have somebody say that you should have done it. But in reality, if that's the only issue, I'm not going to do POs.
Well, you can always pick up the phone and call and negotiate that, but that's an issue. So in Pennsylvania, we have this mechanism called preliminary objections, or POs. It's similar to a 12b6 or in federal court or motion to dismiss in other jurisdiction, which is you can challenge the complaint on legal and technical deficiencies. I have yet to see a complaint where there wasn't a PO in there somewhere, but I rarely file them unless it's something big like jurisdiction, probably the biggest thing, personal jurisdiction, or for the products world, product ID being a big thing. But most of the time you can pick up the phone and call the plaintiff's counsel. It's a 0.5 on a timesheet to get them to dismiss it versus filing preliminary objections or motion to dismiss or 12b6 or whatever it may be. And that's, I think, the bang for your buck that you get. It's really figuring out, yes, I can pick that battle, but do I want to? Because it's money on my client's bill. What do I get from picking that battle? And that, for me, at the pleading stage, I agree with you. I think removal, if you can get a case from a bad venue to a better venue, you're talking about a decrease in pure exposure. You're talking about an increase in likelihood of dispositive motions being a viable exit strategy for you. Those are real value drivers for decisions. So that's kind of what about you guys? What do you think in the pleading stage?
Yeah, just a quick add-on to that. I mean, if you can, one of the things I've done in the past is kind of contacted the carrier and said, listen, here's what could potentially happen with a PO. There's a POable issue. And they'll say, what does that mean for us down the road? Well, here's if it's granted, here's what happens. Here's if it's not granted, here's what happens. And put it in their court and say, do you want to incur the cost of doing that PO? And of course, then is what we always do as best practice is call the plaintiff's counsel and try to get them to stipulate certain things out. Or sometimes it's just as simple as a word or a phrase to get out to really change things. But Oliver, basically, you both laid it out pretty well. But the only thing I'll add is that you when in doubt, always contact the person paying the bills and say, here's a chance of success. Here's what that would mean, and do you want to take on the risk of getting denied versus this cost or not, ultimately down the road. So that's the only thing I would say in addition.
Yeah, and the only thing I can add again is when I look at the complaint that comes in, you have to look at the accounts that are there. I mean, I don't just file preliminary objections for the hell of it. I file them because there's deficiencies in the complaint. The damages that they're asserting. I had a case recently where I filed POs because of the emotional distress counts that are in there. The win off of that preliminary objection has set up my case now going forward into discovery and then on, and sets me up for a good dispositive motion on the back end. So those things you can kind of identify right off the bat when you look at the pleading.
What about punitive damages? Do you always challenge them at the pleading stage? Do you have any steadfast rules as far as what you do in response to those sort of allegations?
No, there's no hard and fast rule. Like, at least not from my practice. I mean, if there is even like a 1 or 2% chance that there could be punitive damages in a case, I'm not going to file a PO over that issue, because even in very conservative venues, you're likely to not succeed in that. And I almost always ask plaintiffs' counsel if they're willing to dismiss without prejudice. And most of the time I'm seeing that they are willing to do that, because, like I said earlier, in products cases, they're a little bit unusual. The one thing that you got to be careful with preliminary objections is, depending on your judge and your venue, if you lose those preliminary objections, you could end up with bad, quote, law of the case. I'm in the middle of that issue right now. I won't say too much about it, but one of plaintiff's claims has no legal or factual basis possible. There is no set of facts that could be proven where this person can recover on that claim. Unless somehow during litigation the legislation changes the law of the Commonwealth retrospectively, or retroactively rather, there's no way that it's not a claim. And I have a PO on that issue right now because co-defendants won't withdraw their PO on that issue, and I want to have a say on the odd chance that we get oral argument that, judge, at least if you're going to deny it, do it without prejudice so that we can readdress this later in the case and we don't face an issue where someone's saying, hey, this has already been ruled upon. This is a good claim, which it cannot be.
I don't know if I agree with you on that. I think the preliminary objection phase is a very different standard. I mean, I see the arguments happening where you raise it early on and then you re-raise it at MSJ level or at the motion to eliminate level, and then you make that argument at law of the case thing. I've never seen that actually work for a plaintiff's counsel.
Oh, it never works, but it's repeatedly used. And when you're trying to explain to your client, whether that's your carrier or the CEO of your insured, they want to say, were you too itchy on the trigger with this issue, and you wanted to put it before the court before we had any facts? That's why in the particular case I'm referencing, which I'm not going to say the name of, but I would have rather been quiet on that issue and then readdressed either through a motion for judgment on the pleadings at the close of pleadings, or more than likely a motion for summary judgment, or partial summary judgment at least. I think that would have been a preferred way of doing it, but we're backed into a corner because of the actions of others in the case. Now, I could still have done what I would normally do. However, I run the risk of not being heard during, the fight over the preliminary objections, in the odd chance that they're actually going to give oral argument, which they, I don't know, what 20% of the time do, maybe.
Well, you also raised a pleading that is used a lot, and maybe there's a reason for it, motion for judgment on the pleadings. So pleadings closes, and then you have the opportunity to file a motion. We don't file them a lot. Mm-mm. Do you guys see this in your practice?
I don't think I have in the last 2 years. I can't think of a time in the last couple of years where I have.
I've done it twice in my whole entire career, and it's very fact specific, and it has to do with how the case, again, you have to look at how the case was brought in. As to Oliver said, what happens on the onset when you get the complaint, the other defendants, how they respond. Defendants get out of the case, they come in. So again, it's something rare that you see, but it is very fact specific to a case itself.
And I think if you have a really strong, tight legal argument, sometimes motion for judgment on the pleadings can be a valuable tool, but you have to approach how you file your answer and what you attach to your answer as advancing your cause. So I've done it a handful of times, more for leverage than anything, more for settlement leverage than anything, but it's not something that we tend to use. So that's interesting. Anything else about pleadings that let's say what you don't do in pleadings?
How you answer the pleading and how you make your cross claims. I cannot stress this enough. I've seen this happen in my practice over and over again. People like to put boilerplate language in for cross claims, and it comes back to bite you at the time of when the discovery is over and trial. Because, if you just say, I file a generic cross claim against defendant X, and you didn't specify what that is, defendant X will use that against you when you go into trial. So it's you have to caution, especially young attorneys that are, drafting these pleadings. You really have to teach them that, you don't just crib off of another person's pleadings. You really have to think about carefully how you're answering the complaint and how you're making those allegations and cross claims.
I would think that the new matters or affirmative defense is the same thing, depending on where you are. If you're in New York or Pennsylvania State Court or federal court, they're called different things. But you can't do that. Attorneys sometimes say, do you have a good premises liability set of new matter or affirmative defenses? And you can't just cut and paste that into something and say that's good enough, because there are things all over. And I had a case recently where plaintiff's counsel missed a allegation in a complaint, and it came back to bite him in an oral argument on a motion dismissed that we filed, that they forgot to mention something. So that was something the court really took into account. So in my aviation cases, I have preemption new matters and affirmative defenses that are based on federal statutes that are aviation based. So you have to tailor those things and take your time, because you get one shot. Oliver mentioned before, use it or lose it. There's no, you can maybe amend it later if you have a motion for leave to do so, but be careful at the outset, because once that's filed, you may be looking at that 2 years later.
Yeah, I think you have to be very cognizant of waiver. Yeah. If you don't include some of the cross claims, not necessarily cross claims, but the affirmative defenses or new matter, you can be deemed to have waived it. My worst story that I ever saw was not me, but it was a co-defendant's counsel probably 5-10 years ago, where they answered the complaint and didn't have any new matter in it. No affirmative defenses whatsoever. And then they went to file an MSJ on something that should have been asserted in the affirmative defense, and the judge, and we raised it, we said you waived it, and the judge agreed and dismissed that his MSJ because he had waived the issue. So you have to be cognizant of what you need to put in there just to preserve any waiver issues, because we do have some standard stuff just for that reason. But beyond that, I think you do have to get case specific.
And just from a sort of a logical standpoint, we see with young attorneys, they want to do a cross claim against every single defendant. Well, it doesn't always make sense to do that. If you have if you're representing the manufacturer of a product, do you want to cross claim against the distributor of that product? You might not want to do that, because you may be sending mixed messages to the jury when if and when that's read back that, oh yeah, the product's defective, but it's really this dealer's fault that it's defective. No, it's not defective. You also may be alienating a potential ally in litigation. You also may be really pissing off your client by monkeying with their business relationship with one of the co-defendants. So you need to be cognizant of that, and not just do something because it's a knee-jerk reaction.
Yeah, always question, well, can I do this? And if I can, should I, and why? I think those are, especially in the pleadings phase, because once that's done, it's done. You can always amend it, but it's the further away you get from the pleading stage, the harder it is to amend. Well, let's talk about discovery, written discovery. Do you always serve written discovery? Do you always serve ROGs and requests for production?
Yes.
That's one of those check the box
in my
things.
practice, yes.
Yeah, I think you have to. You don't always serve the same stuff. You don't always serve the deluge of written discovery that we do in our big cases. You may only serve one set of ROGs instead of 5 or 6 or 7 sets of ROGs. It also, I think, is venue dependent, because some courts are more likely than not to allow supplemental sets later as you go, and some are like, no, this is a machine. You go through these stages,
Well, like in Pennsylvania, you're not limited. Well, at least in a major jury, ARBs you are, but in federal court you are. So you really do have to pick and choose which ones you serve.
I'll give you an example, and I know you guys talk about the products realm, but I'll talk about from a recent auto case that we had. A lot of times before the suit is ever brought, plaintiff contacts their attorney. The attorney sends out a demand package pre-suit, and that contains a number of medical bills, documentation. Plaintiff's attorney thought that the demand package that he sent was sufficient and said, why do I need to answer your written discovery? Well, and the attorney looks at me and says, well, what do I do? And I said, you go file a motion and you get them to respond to the written discovery. You think that they're going to be honest and they're going to include everything in the demand package that they get? Or I've seen people who just file, see attached to the answers to interrogatories, and they just attach a bunch of documents, but they didn't answer the pertinent questions that you asked there. And, we have mechanisms here in Pennsylvania. You can file a motion to compel to get the information that you need, because that's how you properly defend a case.
And I think when it comes to ranking the most expensive things in litigation, serving written discovery is not on the top. It's such a cheap tool, not cheap, but one of the cheaper tools to employ, that serving one set of ROGs, one set of RPDs, or just RPDs, whatever it may be, isn't going to have a huge bill. So
even if you have to do 2 or 3 motions to get that stuff, which we often do, it's still not that expensive. It's nothing compared to doing a battery of depositions that you may have to travel to do, that you may have to serve in a foreign venue, the subpoenas, that is. Written discovery is cheap. It's fairly easy.
Well, if you get insufficient or answers that are not satisfactory, do you always file a motion to compel more specific?
No. Sometimes a bad answer is better than a fully expressive and responsive answer.
If it's a substantive response that's bad, let it sit until the dep, and then I usually bring it up at the dep. I always send a discovery deficiency letter before I do that, and I'll call the person too. I think that oftentimes plaintiffs' counsels that are aware of their case and know where this is going anyway will say, well, they want to do the bare minimum to meet the requirement not to get a motion compel filed against them. And some of them don't even care if that happens. So, but I always do, call first, send an email, let's chat. On the phone, hey, here are the 4 issues I have. We take care of 2 on the phone, put 2 in a discovery deficiency letter to get that memorialized, and then wait 10 days or 20 days, follow up, and if after all that, then file a motion compel. Because while it's not extraordinarily costly, it still takes time to draft it, file it, walk over there, or argue it. There is a cost associated with it. So if you can take care of that over the phone or with a letter, that's much better.
And I think you're right. I think and to go back to that theme, filing it and drafting it actually isn't where the bulk of the money is. It's attending the hearings. If you're in a county like Philadelphia where it's a court call, New York's the same, I understand it, that you could be waiting 6-7 hours sometimes.
I've been heard at 3:42 p.m. in New York.
Yeah. And then you have a 10-hour day before you know it, and that's where the money comes in. So you try to avoid them as much as possible. And then if you can't, you really have to ask yourself if that is an expense to be had.
Well, I like Nate's idea of trying to be civilized and call and work it out, but we have a couple of opponents that they don't give you discovery, not one word of discovery, not one page of document, unless there's an order compelling them to do that. So I'm not going to waste the 0.1 or 0.2 or 0.3 on the phone with those people. I've worked with them enough to know what their MO is, and I'm not going to bother. That's a very small minority of my opponents, though. But they're on the list. Yeah. Here comes the motion.
I did speak to an attorney in New York once, and I said, "Where's your discovery? It's due. It was due a month ago, and I've sent you 3 emails about it. Where is it?" And they said, "Well, no. What you do? Like it's just a declarative statement. What you do is you just file a motion, come up, and then I get 30 days from that point to." It just happens that way.
It's a game to them.
And I was like, wow, I wish you had told me that, But anyway, it's just, to look at it that way, I think is certainly in bad faith. And we could talk about motions for sanctions and what you do in that sense later. But, some people just look at it like, I'm only going to give you the bare minimum and only when the court screams at me to do so.
Yeah.
And that's, we don't operate that way. And we don't like when other people operate that way.
Yeah, I think for me, the most bang for the buck in written discovery is the documents themselves, right? I would rather have the subpoenas out. I'd rather have the medical records in or the witness statements or whatever it may be than actual substantive written discovery. So if I get poor written discovery responses in, if it identifies documents or things that or people that I can subpoena, I'll just go to that source and see if that answers my question.
And I think there's a very real difference in how ordinary people perceive the written discovery responses of a plaintiff versus that of a corporate defendant. You know, I just got discovery in a significant plaintiff's case where the responses that they've given me are patently incorrect. It's, where did you get this document? Right here. No, you didn't. It didn't come from there. I know, because that's my website. You know what I mean?
Yeah,
I know you didn't get it there.
Right.
Whereas, you know, and I think the jury can look at that and go, it's just some regular guy. He probably forgets where he got that or where it came from, and it's not his fault. You know, all he did is sign up with this lawyer. You know, but contrast that with a large corporate entity. If you say something wrong in your responses, they beat you over the head with that incessantly. And a lot of times it's actually more difficult to deal with, particularly if they're in another country, there's a language barrier or something like that. It can be more difficult to communicate than for a plaintiff to pick up the phone, plaintiff's counsel pick up the phone and say, hey, you know, John Plaintiff, what happened here? Okay, all right, we'll put that down. I'll send you the verification. You know, I always find that to be a really stark sort of double standard.
Well, let's talk the second part of discovery, which is depositions. And besides experts, I think this is one of the biggest ticket items, financial items in a lawsuit, because you're dealing with prepping for it, traveling to it, many situations, and attending. And for the largest cases, some of your deps can last a couple days. So how do you approach which deps that you take depending on the case that you have?
Well, I think plaintiffs, if it's a husband and wife or a family, and then you have not any eyewitness. I mean, if Joe was around the corner and heard a noise and that's all that person's going to give you, and it's a relatively minor case, maybe you don't take that. But I can't think of a case where I haven't taken an eyewitness dep as just a matter of course. And I think that we can all speak about this around the table, but that's the one thing that impacts the value the most. It's the one thing that the client and carrier always want to hear about. Is the person likable? How do they present? What did they wear when they showed up? How did they act? If it's on video, show me sections of the video that I think are important. And so, as a matter of course, it's plaintiff and eyewitnesses, and then beyond that, usually we have a corporate designee to put up, and potentially other defendants do as well. But I can't imagine a case where the plaintiff and everyone you can find that was around when it happened, you don't depose.
Yeah, I think the two biggest groups of deponents, most important, of course, is plaintiff. The injured party. If that person is not alive, then the people close to that person, family members, even if they're not married, we may do a boyfriend or girlfriend's deposition or something like that. But eyewitnesses to me are the most important. And ironically, we know statistically that they're the least reliable. I mean, human memory is not great. It's particularly when a person is observing something and they weren't intentionally prepared to remember it. When you went into school, if you were a good student, you walked into that room intending to learn something, to remember it. But if I ask you who walked through the revolving door downstairs before you this morning, there is no way you can remember that.
No.
However, if someone gets to you beforehand and says, isn't it true that Nate walked in right before you? Look at him. Don't you remember that? That happens more often than I think it should in our cases. Either way, the eyewitnesses are the most important bit of discovery in your entire case. As my old boss said, one half-blind drunken wino on the corner who says that car went through the light beats 10 PhD experts that have been paid tens of thousands of dollars because he saw it.
I'll leave this with a caveat, though. I mean, I believe in obviously plaintiff sues you, you take their deposition, eyewitnesses, but I want information before I just take depositions for a lot of strategic reasons, but one being that sometimes you might know something about the potential deponent that maybe you don't want to take the deposition right away. It sounds odd, and it's not something that you do very often. Usually depose people that are identified by the plaintiff, but if they're people, I don't offer people on my side unless you're asking for them. It's one, for cost reasons, two, for strategic reasons, things that maybe that you don't necessarily think will be helpful to the case and will convolute the case. So I just keep that in the back of my mind when I decide who you're gonna depose.
And I'll go back on a little bit of a different point of view. I'm not sure that you always take plaintiff step. Can I say that? Like, there are certain situations where, let's say, Philadelphia County has an arbitration program, as do a lot of the surrounding counties, where cases that are valued less than $50,000 go into the arbitration program. You go to ARB. If there's an appeal, it's the de novo. You start from scratch, although with a lot less of a time frame. I think some situations on those cases where it's an ARB level case, maybe it's like a stub toe. I've had those before. A stub toe that probably should be in the municipal court level, but it's not. Do you take the plaintiff step? I have given the advice sometimes where let's wait till after the ARB. Let's roll the dice at ARB because it's going to cost you way more than this case is worth. If we can get to ARB, we can settle it, or we can, if there's a judgment and we can settle that maybe we don't. I'm not sure that you always take the plaintiff step. I think there are just carve-out situations for when you don't. And I'm not sure about eyewitnesses either. I think the larger exposure cases, absolutely. But I think when it comes to if you have a client where cost is number one, their priority, I think it's a conversation that you have with them. You say, here's what the list of eyewitnesses, how many we have. Can we do them all in one day, right? Can we bang them out all in one day? Do you need the transcript? Because the transcript is the second most expensive part of taking deps. They're typically around $1,000, if not more, depending on if it's more than a 4-hour dep. So some things to consider. But I mean, for the most part, I agree with you. But I think there are some times where you say, you know what, we can probably get away with either waiting or not doing it on this particular case.
When early in my career, when I did a ton of arbitrations, I always took their deps, and I always brought a court reporter to the arbitration itself, because one of my old bosses says, "How do you know when they're lying? Their mouth's moving." So you're building this ongoing record, and more often than not, I found some big holes in their issues, their internal discrepancies, which I think really did help on a couple of cases. I'm thinking of one who was a plaintiff's counsel, was actually one of the professors who taught one of the bar prep courses I took, and he had an absolutely awful plaintiff, and it was a rear end case. I mean, I was like a second year associate. I'm doing this stupid rear ender in Philadelphia. You're gonna pay on it, and she, plaintiff just couldn't keep her story straight, and so we took the deposition. I cross-examined her at her at the arbitration, and at the end she made up some nonsense like, well, I was wrong at my deposition because I had taken a whole bunch of Oxycontin and I couldn't remember what was going on. And I'm like, really? Because I asked you right at the beginning, I'm going to read my part, you read yours. Are you under the influence of any drugs, alcohol, or medication? And what was your part? I said no. So, and the case went away for I think it went away for $1,500. So that was money well spent.
Mm-hmm. Would it have gone away for more if you hadn't have done that? And that's the question I think, in 2020 hindsight you have.
Yeah, I think it was worth it in that case. The other thing that I haven't disclosed here is I was in-house for a major insurance company, so the cost of doing that really wasn't a huge issue. They had a contract with the court reporter where they were paying a really low amount. I was being paid a really low amount, and it in the end it was a different business model, a different litigation model altogether. So, but I still feel weird about walking into a courtroom having never heard directly from the plaintiff.
I've done it and it feels weird. It feels anti everything you're taught in law school is to do everything that you can in the best interest of your client. I think once you get out of law school and you've been practicing 5-10 years and you've had the conversations with the clients about the bills and why you're spending this and why you're spending that, it becomes less uncomfortable. So,
Especially if they're complaining about the bills.
right. All right. Well, let's move on to experts and expert reports. We do with a lot of, most personal injury cases, you have to have some sort of expert. Products, we deal with a lot. Aviation, you have your experts. Do you get experts in every case, and how do you decide which ones deserve expert authority?
Well, what I always ask is, can a layperson understand this on a jury? If not, we would need an expert to support our position, our defense. We have cases. we have lots of cases. We have 0 experts, or usually 1 at least for damages. And then we have, I don't know what the record is all over. 15.
I think we've had like 14 or 15.
15. I think every time I've needed more than 2, and we collaborate in the office. I'll pop into people's office and say, let me give you this case in 3 minutes. I'm thinking these 4. And then someone will say, you need a life care expert. Or someone will say, you don't need an expert. If you have an engineer, you don't need an expert in this little sub-engineering industry. And so I think that we knock that around all the time. And that changes during the course of the case. I think oftentimes after 2 or 3 deps, you say, okay, we have 3. And then maybe after 10 deps, you have 6 or 7 because other things have come up. But just on the damages side, you can usually figure out what you need at the beginning based on the allegations and the medical bills. For instance, we oftentimes go back and forth about a prosthetics expert or a life care planner. Or a vocational expert if there's a lost wage claim. So I think you can kind of set that earlier on in the case than you can the liability stuff, which seems like the opposite should be true, but it's not, because the liability changes over the course of the case more than the damages do. But we do collaborate quite a bit on making sure, because experts are expensive.
The most expensive part,
right.
I think,
and
maybe second to lawyers.
If they're not necessary, you don't want to send a bill to the client
on an hourly basis. They're a lot more.
Well, that's true.
A lot more.
We got this. You always ask for authority to do that, but it's anticipated this expert will be about $8,000, and at the end, between all the reports and supplemental reports and their time and everything, it's $30,000, and they don't want to get that bill if that doesn't, if the needle doesn't move on settlement value or verdict value. Mm-hmm. So.
Yeah, with the products liability defense, you run the risk of not being able to put forth facts that are critical to your defense if you don't bring them in through your own expert. You will always be allowed to cross-examine opposing experts, but as I said earlier, we are not in the business of disproving plaintiff's claims. We're in the business of proving what our narrative wants to establish. So do I always get experts in products cases? Absolutely. I can't remember a single one where I haven't gotten an expert. That might not be true. There may have been 1 or 2 where it was clear that the product was misidentified. It's not our product. I'm not defending somebody else's product. And we're not dealing with some weird market share theory of liability in these types of cases. So barring a misidentification of the product, I'm getting experts. Now, on the damages side, you really should make every effort that you can to share damages experts with your co-defense, because number one, in many venues such as Philly, you're going to get 1 IME per discipline, 1 neurological IME, 1 orthopedic IME, 1 prosthetic IME, if that's what you're doing. The judge is not going to say, oh, well, the plaintiff has to go to 7 different orthopedic IMEs because there are 7 different defendants. As much as I dislike that, it kind of makes sense and seems a bit equitable. But more importantly, you don't want 7 defense damages experts in the same field, because they are going to have discrepancies, and discrepancies do not help. You want a unified damages front. I don't care if Nate and I are co-defendants and we are going against each other on liability tooth and nail. We are allied in terms of keeping the damages down. So we should
And
work
it saves
together.
and it saves both of our clients tens of thousands of dollars.
Oh my
beyond
God.
that, yeah.
Yeah, I think, for me, the damages side of the expert equation, the VOC claim is always something that I go back and forth on. So for when a plaintiff alleges if lost wages or future lost wages, do you always get an econ and a VOC? I mean, that's the combination that you normally get to round out your defense, but do you always need them? I think it depends on the case. Sometimes the VOC claim is so weak that all you need to do is cross-examine the opposing expert. I find that's probably the least likely the situations you more often than not do want your own person up there, but the numbers sometimes, if it's a $400,000 or $500,000 VOC claim, maybe you can get away with cross-examining, and those issues I think you can talk about with your client on whether you get that stuff.
You also have to take into consideration who is plaintiff putting up. When you go through the discovery process, sometimes plaintiff doesn't put a liability expert up. So then do you go get a liability expert? Because you're not, I always tell my clients, I'm not here to make claimants or plaintiff's case. That's not our job. We're not there to bolster their case. So you have to weigh out who they're putting up. If they're not putting up those types of experts, maybe we don't, and you weigh that decision out and you discuss that with your clients.
Yeah. I agree. All right, let's talk dispositive motions, MSJs. I mean, it's really what a dispositive motion is, right? Do you always file MSJs if they're available to you?
No, especially not in Philly. I'll give a big secret here on this podcast. We file MSJs as a way to leverage mediation. Plaintiffs' counsels know that. I've heard. I mean, when we walk into mediation, 5 times out of 10 they'll tell me that I did that. So it's not like a big secret is being unveiled here. But oftentimes if we mediate a case, we'll set mediation for a month or two after discovery ends, and then we'll file an MSJ sometime in that interim period so that it's open and hasn't been ruled upon when the mediation goes forward. So, depending on the venue, depending on the strength of the MSJ, depending on the subject matter, depending on how good the plaintiff's counsel is, or how much he or she has made their case, that can be a really, really valuable tool. Well, certainly if they're granted, it's the biggest win you can have, short of a defense verdict to jury or in front of a jury. But they are a really, really good leverage tool for either knocking out all the claims or 2 of the 5 or 3 of the 4, or and it does make a difference at mediation, I think.
I think it tends to make a difference in terms of plaintiff's counsel's interaction with his or her client as well, because a good plaintiff's attorney is going to have to explain what the pending MSJ means to his or her client and what a granting of that motion would mean. And perhaps that's the first time that the plaintiff has heard these issues. I can't say for sure that plaintiff's counsels sit down and say, look, they filed this motion. If they win, you're sunk. I don't think they're going to win, but here's what they're saying. I don't know if they do that. I think that they probably are obligated to do that. And again, that's getting that issue in front of the plaintiff to, bring back the expectations to ground level. Are you going to win very many MSJs? No, not really. It's a really high standard, and judges are going, if they're on the fence, they're almost always going to lean against granting it. I think you got to be beyond over the fence. You got to be out of the park, But I think that they're valuable tools, but at the same time, they're hard to win. They're hard to draft. I find MSJs to be very difficult to do effective drafting of. Because you have to argue such a narrow confine. You can't just say, well, and then Johnny says this. Mm-hmm. Well, that's an issue of fact, So they're powerful, but they also have limited application, I think. And if I'm not sure I'm going to win it, you're never really sure. But if I'm not sure that it has a really good basis, I'm probably going to opt not to do that. Just save those issues for trial. And
I think it matters what venue you're in and knowing your venue, because in Philadelphia, you're not going to get a hearing. I mean, have you guys ever had an oral argument on an MSJ? Maybe on venue, on COs, but you're not likely to get a hearing on an MSJ, so it's decided on the paper. So it's drafting initial motion and brief, and then receiving plaintiff's opposition, and then maybe a SIR reply, and that's it. But in federal court, much more extensive. Jersey, you're going to get a hearing on that. And the hearing is oftentimes, again, a call of the list. So you could be there all day. And that's, I think, where it starts to tick up in terms of cost. So if you have an iffy MSJ and a venue where it's just filings, it's cheaper. So maybe you take a chance on that MSJ and that venue versus the more expensive one. Again, conversations we have with the client, but that's something that we weigh as well.
See, I like the ones where you get oral argument because
I do too.
You can draw them back. I think it's better.
Yeah.
It is better, but it is also more expensive.
Yeah. I would say that top 3 questions I get from our carriers, our clients, is what's the chance this MSJ wins? That's it's not the most frequent question. It's top 3. And I can't imagine a time where I've ever said 50% or more. It's usually 10 to 40-ish.
40.
Well, I'm a really good writer.
Yeah.
And anyway.
Yeah.
So, but oftentimes they say, well, then what are the benefits? If it's how much is it going to cost? What will it entail? And what are the benefits? And the benefits oftentimes will not be, well, we're going to grant it, but it's all these other things we've talked about. And usually they say, well, okay, let's shoot for it. Why not? We have one shot at this. Let's go for it.
And why wouldn't you? If you know, like if you're in a venue at Philadelphia, it's not going to be heard, it's on the papers, it raises the issue. And again, you use it as, if you lose, it's still used as, the issue doesn't go away. Right. The issues that you bring up in the MSJ, you use it as leverage for when you're talking about settlement, and hopefully getting the numbers down from the plaintiff's perspective.
And we've talked about plaintiffs realizing for the first time, you said, Oliver, that they may get no money. But I've had cases where I file an MSJ and then plaintiff's counsel realizes the deficiencies in their case. I had a case recently in New York that the named partner of the firm was on the case, but the associate did all the depositions. And I filed an MSJ at the end saying, your client never identified the defect. And at mediation, the partner said, what do you mean? That's ridiculous. And we went through the transcript together, which he had never seen. And he was like, oh, crap. Even if this MSJ is denied, I got to go forward to trial and there's no defect. I mean, so, it's like Wendy was saying, it's not just that moment where the MSJ is decided, it's going forward. Plaintiffs' counsel sometimes don't realize the deficiencies in their case.
Yeah. My favorite are plaintiffs' motions for summary judgment. Those are my absolute favorites. They should be like relabeled like motion for automatic win or something. I've only had them filed against me once or twice, and it's so transparently nonsense that my response is like a one paragraph, like, no, this is not how it works.
Well, we have 2 final categories to go through. The second to last is motions in limine, which I think probably the biggest tool to shape trial. A lot of cases don't get there, but if your desired exit strategy is trial, motions in limine are what's going to make or break your case. Agree?
Yeah.
Not agree?
Yes.
Yeah, absolutely. Yep.
Yeah, I mean, it's not just to shape trial, but it's, again, to draw people out of the stratosphere back to reality. I mean, if your opponent is saying, just wait until so-and-so takes a stand and says this, and you're like,
he's not taking the stand.
Order says he ain't taking a stand, or he's been ordered not to talk about this. If that's what you're resting your case, if that's your foundation, maybe our offer looks a little bit better to you. It's particularly powerful with limiting witness testimony, especially with experts, because some of these experts that we come up against will say anything for a nickel, and there's no foundation. I had one 2 years ago in Essex County where plaintiff's expert, there's actually a co-defendant's expert against my client, had no factual basis for his report whatsoever. None. And we were able to eliminate him out of the case. That changed the dynamic dramatically. It actually led to granting of summary judgment because they didn't have a case at that point. So I think motions in limine are super powerful tools, but you should use them like a scalpel, because if you put 15 or 20 in front of a judge, they're likely to just deny all of them. even though there's 2 or 3 in there that are like absolutely should be granted.
Yeah, it's one where you don't throw everything up on the wall to see what sticks.
No.
You really have to pick and choose which ones you file.
Yeah.
And I've actually had a trial a couple years ago where I debated someone on an expert report that had no basis to it, and I was debating whether or not I let the expert in. It actually would make my case. I still won the case, but I made what he was saying actually helped me even more. So I'm like, do I let him in? I filed a response or whatever. He never testified in the case, but those things I weigh out too. Like what do you want to see go into trial? What do you want to see get out of trial?
Yeah, I like it. Last topic is kind of the miscellaneous courtroom shenanigans, extras that don't fall neatly in any of those categories. What sort of things would you add to the list of this X gets you a really great ROI on value or whatever it may be? Big bang for your buck. What are some of the things that we should consider?
It's your quality of presentation, how you appear to that jury. And that doesn't mean that you have to be flashy. You don't have to come in with fancy AV equipment to show demonstrations, but just how you present. And I largely think that has to do with how you interact with your opponent in front of the jury. If you're glaring at them and when they're giving their opening or doing cross-examination, you're like, psh. Like, I think that comes across as like weak. I mean, sometimes we all do it, not intentionally, but like, it's important to appear as though you're in control of this situation and not to flinch whenever they say something ridiculous in the courtroom. I also am a believer in limiting your objections to the greatest extent possible, because all you're doing is really drawing attention to things. You may want to draw attention to a certain thing, but that's important. How you present is super, super important. Some of it is just your posture and how you behave. One of the really great attorneys that was at my old firm, who has since left, I understand, he had the greatest courtroom move I've ever seen. When a witness would go off the rails on a tangent, saying stuff that he shouldn't be, he would be standing there and he would just go, for those just listening, he'd just put his hands up like, whoa. He wouldn't say anything, and most of the time the person would sort of back off. And if they didn't, they looked like they were being like adversarial towards counsel. And it really was a really powerful tool. Similarly, we had a very big trial in New Jersey, and plaintiff's counsel, who comes from an exceptionally well-funded, big, powerful plaintiff's firm, multi-million, maybe even hundreds of millions of dollars in verdicts, strolled in wearing the frumpiest outfit you have ever seen. She looked like like she went to Goodwill and bought her clothes.
Oliver,
like,
you do know this is 2020.
Yes.
You can't say that.
it was. I can say it because she did it intentionally. He orchestrated this image for the jury of the Aaron Brockovich against the big, giant, multinational corporation. She dragged with her one associate, and we had a team of there was up to 10 of us in the courtroom at that time. We had cases and cases of evidence. She had one little rolly bag. She reminded me of my elementary school librarian. Nothing could
who obviously is going to play well in front of a jury, right?
Yeah. Nothing could be further from the truth. She had like the crappiest exhibits that looked like arts and crafts had been, cut out with like the play school scissors, and she rented a cheap car to drive the injured, and she personally drove injured plaintiff to the front gates of the front door of the courthouse, where the jury also came in, So
she's smart.
So she's not driving. I believe, I could be wrong, but I think she either had an S-Class or a Bentley that she drove around in. Instead, she's had like a Chevy Cruze.
That's awesome.
I wanted to meet this person. This is great.
And it was absolutely obscene. and the jury bought every morsel of it. They were like eating it up. So the moral of the story is that stuff works. So,
What about you? I'll add mine real quick. But I think early online mock juries for the right case can really give you a good bang for your buck. You can learn a lot about whether your story will play, what pieces of evidence the jury latches onto, what themes you should develop. It's a little expensive, but for the right case, I think that is an expense that people should be considering, especially in the age of nuclear verdicts, this new term that everyone's using now. I think for those right cases, it's a great tool. What about you guys? Any closing statements?
Yeah, I think the two things you could do, and they cost, well, not nothing, but next to nothing, are one, be in complete control of the evidentiary record, know everything. That does take time to review and make notes and things, but if you go to a plaintiff step and you're super well prepared, and you can quickly move to a tab and say, nope, in interrogatory response number 52, remember you said this and it's your signature at the end and you just testify. If you can do that and look the part and act the part and be confident in front of the client, in front of plaintiff, him or herself, that does wonders. I mean, I've heard family members talk in the hallway about, and it wasn't me, I wish it was, a co-defendant's counsel saying he really knows his stuff. Oh man, they're really prepared. They're not just going to roll over and settle this case. So I think that's number one. The other thing you can do is act in good faith and be kind to plaintiff's counsel. If you act, if they say, listen, I need this, it's not objectionable in any way, don't play the games where send me a written request. If you say, sure, no problem, I have that, I'll get that to you right away. I'm just going to redact this one. I mean, if you act and are in control of your knowledge of the record and you act kindly and in good faith with opposing counsel, that projects a lot of confidence and strength, and they'll respect you back, and I think it changes the value of the case over time. I really do.
And I think it changes, it changes the bill too,
Yes.
because you are going to get favors that you probably wouldn't get. You're not going to have to spend money on certain fights.
Yep.
Another thing when we're talking about bang for the buck, you're here trying to save client money, but when you're getting into trial, one of the biggest things that I put out there is technology. A lot of courtrooms are not don't have the technology as others. Still do not have the technology as others. Had an argument years ago about getting something called an Elmo that you set up in front of the court to show your exhibits. Because at the time, you don't want to be fiddling around with your laptop. It's like a projection screen. You can just put your medical document, you can talk to the witnesses, you can ask the questions. Just that amount of money, even though it's an expense, trial is expensive. That makes you look better in front of the jury. It makes you look organized. It makes your court case run more efficiently, and also you can talk to your opposing counsel. Hopefully, you have not alienated them by the time you get to that case, and you share the cost.
Mm-hmm.
Well, I love it, guys. Great podcast. Before we wrap up, any other closing statements?
I wanted to address a concerned viewer's comments. We'll call him Bob. Let's leave it at that. Apparently, I got some facts wrong in the Legal Movies podcast. The judge in My Cousin Vinny was not Lurch from the Addams Family.
No, he was Herman Munster.
It was Herman Munster, who is played by Fred Gwynn. Sorry. I don't know that the Munsters was even in syndication when I was alive.
Oh, please.
Oh, yes, it was.
Oh,
I
come
don't
on.
think so.
You're not that much
48.
younger than me, and it was when I was growing up. All right.
That's my cue not to say anything.
The same
more.
concerned viewer said that I got Jack Nicholson's character wrong in A Few Good Men, which I looked up and did. So, Bob, I'm sorry on that note as well.
I say
Air quotes.
I say kudos to Bob for bringing it to our attention.
Yep, someone's watching with a
We
very
have somebody
discerning
watching,
eye. Yep.
listening. All right. Well, listen, great podcast. If you guys like what you hear, I really appreciate a comment or subscribe or a like, whatever you prefer. But until next time on The Defense Never Rests, see you then.
See you.
Have a good day.
Bye.